Est-ce que Gönenç, à votre avis, les autorités de concurrence ont une expérience suffisante pour traiter tout genre de dossiers, tout genre de questions? Quelles sont les questions qui, selon vous, devraient être dirigées vers des experts et lesquelles peuvent être sans expertise, être traitées par les autorités de concurrence?
Thank you very much. I thank you for this question, and the quick answer is going to be an obvious no, I think, in the sense that no authority or no gathering of human beings could have sufficient knowledge to regulate all markets, and they will need outside help. Well, I should revise that. Outside help, or they should need to build internal capacity, and that's also a delicious conversation to be had. Should the authorities try to internalize as much expertise as possible, or should the authorities rely on outside expertise? That delicious conversation is going to lead to another debate probably on whether it adds more credibility to the stance of the competition authority if that competition authority were to be using outside help. Does it mean that if the expert is on payroll, then the expert is deemed to engage in some form of reverse engineering of expertise to allow for a case? The same could obviously be said for defense counsel and defense positions as well. Is an economic consultancy firm that is constantly working with the same client less credible than one that sporadically works, and all that. Now, not getting into the credibility of the experts issue, though, and staying with the question that was posed to me, I would like to invite also a thought on the matter of legal realism, if you will, in the sense that the decision-making bodies will eventually have to own up to their decisions. So while it is admirable to use experts and to get the expertise of the experts into the files, it would be quite dangerous for antitrust agencies to alienate themselves from the very decisions that they are coming up with. This would mean that antitrust agencies would, over time, start treating their files as if there is a machine where they're feeding the facts from, and there are experts churning, and we don't understand as defense counsel, and they don't really understand as the authorities, and luckily the machine is delivering us the result. So this should be avoided as well. So then the question becomes, what exactly is it that you should be asking to the experts, and how transparent you should be? And the answer is very transparent. To the defense counsel as to in what capacity you are handling the input. Now, if the antitrust authorities are owning up to their own decisions and are saying, this is the point where I have relied on expert testimony, and this is how I checked the expert testimony, at least it will be possible to test the reliability of the expert testimony, because now we know through the abundant use of economic analysis in expert form that it does very frequently come down to your word against my word. I don't want to make any economist upset, and I have very good economists in my own family as well, so it would run against my grain. But truth be told, after 25 years of practice in the legal world, I am finding it difficult to distinguish between lawyers and economists anymore. Economists are also slapping the data in a given way and are using their convenient models, and very credible two economists can be saying black and white in the same exact pattern. If this can happen in a world where a science is being used, not an exact science, but a science like economics, then imagine what would happen when we're trying to define markets where engineering expertise is required and we really don't understand what is being discussed. It is important that we employ, for remedy structuring, for effectiveness analysis of remedies, for ecosystem effects analyses in digital markets, for counterfactual analyses, for feasibility analyses of what is given as a homework expert approach, but also in the market definition matter as well. Sometimes case handlers might find the life experience embedded in them. If the question is there a separate market for premium beers? Maybe a case handler might have a life experience in this. But if the question is, as I was struggling with some 18 years ago while I was practicing in Brussels in the Microsoft case, the question of interoperability data. Which bit of this data belongs to the company as the blueprints of its engineering? Which bit of this data is necessary for interoperability? Then obviously you will need expert testimony, but that will have to be tested very thoroughly. The reason why I'm choosing this example is I think this is a debate that has been going on for more than 20 years now. And as digital markets are a prevailing feature of enforcement, this is going to become an even more critical question.
Fort rapidement, la définition de marché est toujours utile. Les économistes n'en sont pas toujours amoureux, mais nous devons le faire. Et alors, une chose qui est très importante dans la définition de marché, c'est de commencer par se demander si on a deux produits, si ce sont des substituts fonctionnels. Je sais qu'on passe toujours notre temps à dire que ce n'est pas suffisant, mais c'est nécessaire dans la plupart des cas. Et là, évidemment, pour la bière, comme on en a parlé, nous avons une idée, mais s'il s'agit de médicaments, ça devient un peu plus difficile. Surtout que pour nous, pour définir le marché, ce n'est pas juste de savoir si deux médicaments sont substituts ou pas, mais pour qui et quelles sont les tailles relatives de ces différentes populations. Donc là, nous avons besoin d'un expert dans ce genre de produit, et aussi d'un expert de ce genre de produit, et ça s'applique à tout ce que je veux dire aussi, qui est aussi capable de communiquer avec nous. Parce que, bon, tout qui a essayé les experts, c'est ce dont je parle, mais parfois cela peut devenir très, très difficile. Dans un cas que nous traitons pour l'instant, qui concerne donc la lecture de l'ADN et l'utilisation de cette lecture d'ADN pour développer donc des tests de détection. Bon, ben, des machines de lecture d'ADN, il y en a qui se basent sur la lecture courte et la lecture longue. Et en principe, il y a une bonne substitution, mais ça dépend pourquoi. Pour faire certaines choses, il y a une bonne substitution. Pour faire d'autres choses, il n'y a pas de bonne substitution. En plus, les gens disent, oui, mais d'ici 3 ans, la substitution sera parfaite. D'autres me disent, non, non, pas avant 15 ans. Vous pouvez imaginer, quand vous êtes dans un domaine comme ça, si vous vous basez juste sur l'information des parties ou sur l'information des parties adverses, ce n'est pas facile. Et c'est en fait quelque chose que nous faisons assez souvent à la Commission dans ce domaine. Right? Très rarement, nous prenons nos propres experts médicaux. Nous nous basons sur les parties et puis sur le reste du marché. On dit, bon, est-ce que les parties ont dit, est-ce que c'est vrai ou pas? À mon avis, bon, c'est une erreur. À mon avis, nous devrions avoir nos propres experts médicaux. Ça devient aussi très prospectif. Par exemple, dans un même cas, si on regarde sur le marché en amont, il y a une question de savoir s'il va y avoir des concurrences potentielles et quand. Et ça dépend d'évaluer le genre d'approche. Par exemple, si on fait un test qui détecte plusieurs maladies, est-ce qu'on doit commencer avec ça en tête ou est-ce qu'on peut commencer avec un test pour une maladie et puis le développer? Bon, ben, certains nous disent que cette deuxième approche est la bonne approche, d'autres nous disent qu'il n'y a aucune chance de succès. Et tous ces aspects sont donc absolument cruciaux pour notre analyse. Et pour terminer, ce n'est pas juste dans le domaine médical. On a déjà évoqué le problème de AdTech, où il y a plusieurs niveaux verticaux qui interagissent et qui ont deux côtés du marché, et ainsi de suite. C'est très compliqué. Et de ce point de vue-là, il ne faut pas non plus trop se reposer sur l'expertise que les équipes développent au cours du temps, même si c'est de l'entêteuse et que ça prend du temps. Pourquoi? Parce que imaginez que vous prenez une décision, elle ira en appel, ça prendra du temps. Quand l'appel viendra, la plupart des gens qui étaient membres de l'équipe et qui avaient donc développé cette expertise, ils seront partis. Donc vous devrez défendre cet appel soit en amenant à ce moment-là des experts extérieurs qui n'étaient pas impliqués au départ, soit en disant des gens qui n'ont pas eu cette expérience qui leur a donné une certaine connaissance. Et comme nous sommes pris par le temps, je m'arrêterai là.
Gönenç, your views?
Thank you very much. I think one thing that I would contribute to what the system could do, the competition authorities and the judges could do to elevate the level of expert testimony that they get is perhaps, and this is particularly prevalent in emerging markets. So I'm now practicing in Turkey, and the Turkish competition authority is quite well-rooted and sophisticated in certain ways, but still culturally as well in certain emerging markets, certainly in Turkey as well, there's a dire need to look cool. And you just want to disseminate the feeling that you know what you're talking about. And I'm not saying that competition authorities in more sophisticated parts of the world are exempt from this. I think what I am saying is that it should be okay for judges and for competition authorities to be really loud about the fact that they believe the expert is fudging the issue. The expert is using too many acronyms. The expert is too verboised in the report. I'm not under a duty to understand all this. Distill it for me and feed it to me the way it is helpful. Now, there is a difference between accepting the report and then being overwhelmed by it and throwing it away, and actually giving a response to the client that is before them or the law firm that may have phoned the expert and actually embarrassing them. I think embarrassing them is good service to competition law in these circumstances. If judges were to do this more and the competition authorities were to do this more, in the sense that they ask for sharper, more consumable feedback coming in, this is going to change the behavior of the experts as well. At the moment, I think the experts are getting away with too much. And there's only so much the lawyers can ask in terms of how to sharpen the expert testimony, because at some point they're replacing the authority, at some point they're replacing the judge, saying this is not the bandwidth of the judge and this is not the responsibility of the judge. They're not going to read this long paper, they're not going to sift through this vomit of facts, and they're not going to try to gather what they need, and they need something, so give it in an understandable format. Obviously, whoever is representing a company is under a duty to serve that, because that's how you win a case. But at the same time, I think it would be quite audible if the decision-making bodies were to not be so silent about subpar elements of file coming in, and their way of differentiating is this one I understand, so I'll read that. This one I don't understand, so I won't read that, but no one will know. There's a difference between the two levels of transparency, and I think that could do great service to the expert testimony use in competition law.
Oui, alors c'est une observation et après une question. J'ai été référendaire quelques années au tribunal de l'Union européenne et ce qu'on constatait souvent, c'est que les parties ne demandaient pas le recours à un expert. Alors que cette possibilité existe, elle est prévue par le règlement de procédure, je crois que les articles 96 à 100, et il y avait vraiment, et je crois qu'il y a toujours, une volonté encore d'améliorer le contentieux, de le développer, en faisant participer les experts à la procédure. Donc ça, je crois que c'est quelque chose qu'il faut garder en tête dans la procédure devant le tribunal. Et deux, une question, alors pourquoi? Est-ce que c'est parce que cette possibilité n'est pas connue par les parties? Est-ce que c'est parce qu'effectivement on préfère laisser le litige et le choix au juge que le déporté soit un expert dont les conclusions peuvent être parfois inattendues? Donc est-ce que vous avez une intuition là-dessus?
Je crois que c'est moi qui vais devoir répondre en tant qu'avocat. No, go ahead. No, go ahead. Other panel members, so go ahead.
Thank you. So in my experience, what happens quite frequently is that the parties we represent are really hesitant as to whether we would be giving a bowl of soup to the judge that is going to be very difficult to sift through. And they feel argumentation is easier to consume. This is wrong. At that level of court, obviously, it's helpful if you take advantage of it. But you would be surprised that with some clients, you really come up with a significant resistance, that they feel the courts wouldn't like this type of very technical approach. And if they do, then the judge is still able to ex officio invite this kind of help into the file anyway. I think this is evolving, though. I think there are less and less of these forms of waiver, if you don't disagree with me, and more counsel are making use of this procedure. But back in the day, particularly, especially chief legal counsel that didn't have a competition law pedigree at all would come up with an approach that said, we don't want to confuse the court, let's keep it simple and direct and argue the case. To the extent they need anything technical, then they will reach out anyway. Now I think this is better understood that this is wrong, because if the chief legal counsel is still there and the evolution of the internal structure hasn't happened to allow for a chief legal counsel who has a competition law pedigree, at least there is a position called competition counsel, senior competition counsel, someone that can talk some sense into the to the in-house counsel, which is not always the outside counsel, I'm afraid.